Welcome to Employment Law This Week. I'm George Whipple. September was a busy month in employment law, the highlight of which was the contentious confirmation hearings on Brett Kavanaugh's nomination to the Supreme Court. With the outcome of Kavanaugh's confirmation still uncertain, the court's term begins today with a flashback to 2016. 8 justices and a 4-4 ideological split with no clear majority. A tie decision leaves the lower court ruling in place. The Me Too movement has had an undeniable impact on the process, as the once nearly certain confirmation of Judge Kavanaugh was derailed by allegations of past sexual assaults and misconduct. It's an important reminder for employers that allegations alone can create major problems for a company without the right processes in place.
I think if the Me Too movement taught us one thing, it's that employers face significant liability and risk in the event that allegations are made against any employee or supervisor or the highest level executive at the company. And sometimes those claims are insurmountable for a company and they don't survive. Now, that case is rare, but it certainly has happened. But even in the case where the company does survive, it can do significant damage, not just in terms of money, but in terms of reputation. And in that way, it makes it very difficult for companies to hire new talent and to create that great culture that every company wants.
The NLRB, with its Republican majority, has continued to undo the legacy of the Obama-era board. The NLRB is taking steps to replace the Browning-Ferris joint employment test with a more employer-friendly one. The agency will also likely overrule its decision in Purple Communications that established the right of employees to use employer email for organizing and other union activity. On joint employment, the board published a proposed rule that would restore the direct and immediate control standard which was in place for 30 years prior to Browning-Ferris. Steve Swirsky has more.
The board in December 2017, in a case called Highbrand Industrial, sought to overrule Browning-Ferris and to adopt a standard very similar to the one in the proposed rule. In February 2018, the board essentially reversed itself and set aside the decision in Highbrand and reinstated Browning-Ferris because it found that there was a conflict of interest or a significant potential conflict of interest on the part of one of the board members who had participated in Highbrand. That board member is still a member of the board, and he is one of the board members who voted to publish the proposed rule. I think it's reasonable to foresee that the labor movement and other advocacy groups may attempt to challenge his participation in the rulemaking as well on the basis of a conflict of interest.
Last month, the NLRB General Counsel urged the board to reverse Purple Communications, which could spur action soon. Legislation has been introduced in Congress to both expedite and undercut the NLRB's position, so the November midterms could have an impact on the outcomes. On top of that, over the objection of many in the business community, President Trump nominated Mark Pierce, a Democrat, first nominated by President Obama, for another 5-year term. All of this illustrates just how difficult it is to turn the ship in a different direction when it comes to the NLRB, where the policy impact of presidential elections is sometimes not felt until years later. And big news from the gig economy. The Ninth Circuit has decertified a gigantic class of Uber drivers. The named plaintiffs sought to form a class of hundreds of thousands of drivers to challenge the company's classification of them as independent contractors. Reversing a lower court's ruling, the panel found that the claim should be arbitrated individually by any driver who signed the company's arbitration agreement, which included a class waiver. A majority of the drivers involved signed the agreement. The court noted that the Supreme Court's Epic System ruling found class waivers legal. The plaintiffs are considering an en banc appeal. And finally, we're just a few days away from New York State's new sexual harassment laws taking effect. Starting October 9th, all employers in the state will be required to institute a sexual harassment policy and begin annual anti-harassment training for all employees. We're awaiting final word from the state, but proposed guidance states that all current employees must complete compliant training by January 1st, 2019. New hires must be trained within 30 days of hire. The law applies to all employers in the state, no matter the size. Next year, additional training requirements will be mandated by the City of New York. To dive deeper into these employment issues and much more, join us in person at Epstein Becker Green's annual Workforce Management Briefing on October 25th. I look forward to seeing you there. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.